And third, the one being appointed must be qualified. So, according to the Constitution, by March 10, the President no longer has authority to make appointments except to the executive department. Before March 10, she has still authority to appoint. Can she make an appointment that will take effect when she no longer has the power to appoint? Again, the principle in the law on public corporations is that an appointment to an anticipated vacancy is valid if by the time the anticipated vacancy arrives, the appointing authority still has the authority to make the appointment. So it would seem to be therefore that any anticipated appointment of a Chief Justice prior to March 10 would violate this principle of law. Now, let us assume now that the President goes ahead and makes the appointment. Let us assume that the President appoints Antonio Carpio as the next Chief Justice. It would be a violation of the Constitution because when the vacancy occurs, she no longer will have the power. And then, appointment is a two-way process. It involves offer and acceptance. If there is no acceptance, there is no appointment. So that whoever appoints, or whoever accepts an appointment that is unconstitutional, becomes an accomplice in the unconstitutional act. And that would be a culpable violation of the Constitution, which can be the subject of impeachment. So if the President wants to get rid of any of the justices, all he has to do is appoint the justice he wants to get rid of so that he will be impeached as soon as he accepts. But then you'd probably say that impeachment does not work again. So this is where we are now. It is being said that because of the importance of this period of elections, it is very important that we should have a Chief Justice. Well, let's go back to the deliberations of the Constitutional Commission. Commissioner Lerum was very concerned about making sure that there is no vacancy in the Supreme Court for any long period. So he proposed that any vacancy in the Supreme Court should be filled within 2 months. 2 months. 60 days. 60 days. At that time, when he made this offer, the Supreme Court was still consisted of 11 justices. So, but then an amendment was proposed saying, let's make it 3 months, 90 days. That was readily accepted without debate, in spite of the fact that the composition of the Supreme Court eventually became 15. So the question is the absence of a Chief Justice for a brief period fatal to the life of the democracy? Well, the normal procedure in the Supreme Court, whenever a Chief Justice is absent for any reason, is that the most senior of the justices takes over to take care of the administrative duties of the Chief Justice. And that is what will happen, I think, if when Puno retires on May 17, the Supreme Court itself will designate one of themselves to be the presiding justice of the Supreme Court. And we have to remember also that there are two powers, there are two concerns of the Supreme Court: administrative concerns and substantive concerns. The administrative concerns are taken over by whoever is the Chief Justice or acting Chief Justice. The substantive concerns is the concern of everyone. And how many justices are needed to decide a substantive issue? 8 justices. 8 justices constitute a quorum, so that the Supreme Court can even declare a law unconstitutional. 8 justices is a quorum, and if they deliberate, 5 justices can declare a law unconstitutional. So really there is, I don't see much problem about the temporary absence of the Chief Justice, especially when you consider that very likely the next Chief Justice will be one of the justices in the Supreme Court now. Now, if you say that the justices, the 14 justices of the Supreme Court cannot handle the problem in the absence of a Chief Justice, I think you're insulting the justices of the Supreme Court. So, what else can I say? Now, of course, a very clean way of settling this, clean, that is constitutionally, is if Chief Justice Puno were to retire way before the start of, way before March 10, in which case the President can appoint. Now, I don't know if Justice Puno would like to make that his legacy after a distinguished legal career. So very briefly, I think I have covered what I wanted to cover. The issues, the legal issues in the matter, I think are simple enough, especially if we're willing to accept the proposition that when two laws are in conflict, in apparent conflict, effort should be made to make both of them